Welcome to The Print. On 15th August this year, India will be celebrating its 77th Independence Day. However, this month also, August also marks another anniversary. Back in August 1958, over 6 decades ago, the Lok Sabha and the Rajya Sabha debated the Armed Forces Special Powers Act. Now, just to let you know, the law was initially introduced as a short term measure to counter armed separatist movement in the Naga Hills. In fact, the law was initially called the Armed Forces Assam and Manipur Special Powers Act. After a few amendments, it became the Armed Forces Special Powers Act, and it has been controversial since. The law gives special powers to armed forces to control certain disturbed areas, and this is the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra Sinha, who you've seen in all our episodes of Laws of the Land, and we have with us Supreme Court advocate on record, Astha Sharma. Thank you so much for joining us, Astha.
Welcome, Astha, to the show. As Apoorva pointed out, AFSPA was actually introduced for the Naga Hills area, and it was meant to be a temporary law. What prompted the government to make it like a permanent legislation, and why was it extended to the other states? If you could just throw a bit of light on this before we go ahead with what ASPA is all
See,
about.
Bhadra, AFSPA, like all the controversial laws in our country, is of course of a colonial origin. The reason why it was first enacted was that after the Quit India movement was announced in 1942, a day after that, leaders like Mahatma Gandhi, Vallabhbhai Patel, Jawaharlal Nehru were arrested. So the movement became leaderless just a day after that. So, and violence erupted across the nation, and that was when the Viceroy decided that yes, we have to have a law to control the internal insurgency. So, just to curb that, the AFSPA was enacted back then before the Constitution as well. Of course, once the Constitution came into place, there was a federal structure. The laws were enacted for the Northeast states, for the J&K state, and for Punjab and Chandigarh specifically in three separate legislations. The Naga Hills or the northeastern states are the most talked about because that was where the armed insurgency or armed rebellion, as we call it, was most at that point in time. Right. So, as on day, also the Central Act, as we call it, is specifically towards the 7 northeastern states, but we also have a separate edition of J&K as well as Punjab till date. So, that was the reason why it in fact came into place.
Okay, so is there any difference between the colonial era law and the post-independence?
There is a marked difference. Why? Because in the law that we have as on date, the armed forces or deployment of them is in aid of the civil power. So the center doesn't take away the powers from the states. If the state machinery, the state police or the state machinery as a whole is inept to take care of insurgency or incidents of violence or in disturbed areas, etc., that's when in aid the center deploys the army, which wasn't there in the pre-constitutional era. So what happens is that it's often misunderstood that army has gotten these absolute powers of doing whatever they want, but in fact it is the central government, the state government, which notifies its area as a disturbed area. So that notification under section 3 of the act has to come from the central government of the state. So the state gives inputs to the center that these are the areas that we have identified within our states which are disturbed in the sense that there are a lot of insurgency movements, etc., which needs to be curbed. After this information is processed by the central government, either the entire state or a part of it is then notified as a disturbed area.
So which means that it is not necessary that the entire state should come
Yes,
under AFSPA.
in fact,
it could be just part
absolutely,
of it as well.
absolutely. In fact, even as of March this year, a lot of areas in Nagaland and Manipur were withdrawn as disturbed areas. As and when the situation improves, the government reviews its decision. In fact, any notification that comes under section 3 for a disturbed area is only for 6 months.
Okay.
So after every 6 months, the situation on ground has to be reviewed. If it is seen the situation has improved, the government withdraws the notification and that area no longer comes within the AFSPA.
Can the
Yeah.
central government suo motu withdraw it, or is it that the state government has
The
to
center
recommend?
will, of course, ask the state because the state would know better on the on ground situation. So they would say, suppose that 6 months have expired, what do you say? What are the intelligence reports, or what are the on ground reports? Once the state submits its reports, the center, if it feels that there's no more required for that area to be notified as a disturbed area, it will withdraw its notification. And then, of course, the armed forces will not have those powers within those areas.
So AFSPA per se is not, if a state comes under AFSPA's notification, it per se doesn't really comment on the law and order situation or the state's inability to look after the law and order
Not
situation.
at
Is
all.
that so?
Not at all, Bhadra, because the constitution itself provides for it. If you see, entry 1 itself says that the union can make laws to aid the states in, and they can deploy armed forces in 8 of the states. So if there is a situation where the state government is doing XYZ thing, but the center or the state feels that we need external support as well, it no matter means that the state cannot independently handle it, but it's only in aid of it. That's why the consultation of the state government is extremely important. So the federal structure is also taken care of. So once the state says that yes, we also feel that there is external support required by us, by any of the armed forces, be it the army, air force, or be it BSF or say CRPF, etc., all of them can then be deployed as per the requirement of the state.
So AFSPA doesn't really necessarily include armed forces, but it also includes the paramilitary forces.
So armed forces under the AFSPA is defined as the forces that we have, Indian Army, Air Force and Navy, and includes the central forces as well. The definition itself provides for it.
Let's talk about the contours of the act. So, the purpose of the act, of course, you have shed some light on it. But what exactly does this law do?
So, see, Bhadra, we have to understand that when the armed forces are working in areas which are so volatile that, even in a fraction of seconds, the situation can on ground change to such an extreme level that it might not be possible to take permissions or sanctions from your higher ups, be it for shooting somebody, for arresting somebody, for search and seizure. So when the armed forces are actually functioning under such extreme conditions, they need certain kind of powers. These powers under the act broadly would be that if they see that there's an unlawful assembly with firearms, etc., then there can be a shoot at sight order. There can be arrest of people without warrant. If they see that there is a bunker or a shed or a shelter which needs to be destroyed, no further permission is required, it can be done. There is search, entering, seizure, all of that can take place without further permissions. And if any of this is done in a bona fide manner by any armed forces personnel, then they have complete immunity, in the sense that any proceedings will then have to be only after the sanction of the central government.
But then, you say that, they have complete full power to go ahead and take whatever action they would like to. But are we also trying to say that there is no authority to control them, or there is no authority to whom the forces or the person are supposed to report, or can they just go and start shooting anybody, or go and just start
I think
raiding
that's
anybody?
the perception, Bhadra, everyone has, that there's no checks and balances in place. But we forget is that our army, specifically the central forces that we have, they actually have such discipline, and the training is so strict that they have these internal mechanisms in place. There are guidelines of do's and don'ts in all the operations, which of course also follow in operations under the areas, disturbed areas as well. So there are certain guidelines for what needs to be done before the operation, in terms of you have to have the intelligence report, you have to have complete briefing on what are we actually looking for. Suppose if it's an operation for they have intelligence input saying that there are certain mobs that are gathering with arms, etc. So first it has to be verified whether the information is true or not, how much manpower is required. People are briefed that you can only fire upon once you are assaulted, etc. During the operation also there are drills in place which says that you will first warn the person. If someone's attacking you, you will first warn. If you're opening firing, you'll have to do it on the air first, then also below the belt. Even after that, since I'm going to repeat this, that it's in aid of the civil police, etc. So in all these operations, as much as possible, the civil police will be involved.
Okay, so
Okay.
it cannot be
It's not, yes.
just an operation by the armed
Yes, so
forces,
it's
which is
not a
their
trigger
request.
happy army or the armed forces going and doing what they want to. And even in situations where the local police couldn't be looped in because of the urgency of the matter, if there are arrests made, if there are seizures made, they have to be handed over to the local police immediately as per the CRPC. So it's not that if I've arrested a random person in one of these operations, I get to keep him with me and take him back with me. No, you have to hand it over to the local police, and then the law will take its course.
Is there any recourse that individuals who are aggrieved by actions of armed forces in these disturbed areas have? Do they have any recourse?
Of course, there have been a lot of FIRs that have been registered. In which cases, what the usual course is that the concerned army channel or the central forces channel is informed about it. There are internal inquiries that they have, court of inquiry, etc. If they feel that yes, there is something that has to be looked into further, either they themselves carry on the investigation, or if the central government so grants sanction for prosecution, then in the civil courts also these people can address their grievances. Yeah.
Have have there been cases where the central government has granted this sanction, and what happens then? Is the case then normally tried as a normal trial?
So see, usually what happens, Apoorva, is that the laws itself provide that if two courts have jurisdiction, that means the army can also try it, or the civil courts also have competence. It is up to the decision of the army authorities to see whether it has to be dealt with by them or in the civil courts. Also, when we talk about sanctions, then there have been instances in the past in J&K where the central government has in fact granted sanction for prosecution, because the material before it was so glaring that they could see prima facie that this was not a bona fide operation. But this scrutiny has to be done at a level where somebody who understands what the operation was, what was the force used, the mechanisms or the methods that was adopted, were they legitimate or was there any transgression of the rights, etc. It's only after that the sanction is granted, in normal course.
And can the lack of or a non-grant of sanction be challenged anywhere?
So yes, it can be, but technically then this would have to be done by the states, because once it becomes a criminal case, the FIR, the charge sheet has been registered by them, then technically it's the state's responsibility to charge non-grant of sanction. But more than that, it's not done, because the scrutiny itself is, like I said, it's such a high level that once the central government decides that no sanction has to be accorded, then it's assumed that all checks and balances have been taken place, and it has been dealt with at the highest possible level. So there have been no instances where the sanction, non-grant of sanction, has been challenged. But yes, we have seen few cases even after the Supreme Court where this non-grant of sanction has been challenged, but the court has only opined that yes, you should have ample material to evaluate, etc. Once you've put your mind to it, then it cannot ordinarily be assailed.
So, but despite the objectives which you have spoken about, that AFSPA is meant to purely aid the state government in terms of internal insurgency, why is this law, why has this law become so controversial, particularly in the context of the Northeast? There have been many allegations of violations by the armed forces personnel, and in I think in one or two matters, even the Supreme Court has gone ahead and commented on it. Can you just share
See,
with us on
Bhadra,
this?
I believe that no organization in a country is above criticism. There have been instances where the armed forces, which also includes, like I said, the centrally deployed forces, have been accused of incidents of violation of human rights. There have been cases of sexual harassment, rapes, be it from J&K, be it in the northeastern states, from the armed forces, or as we call the central forces, which includes the Assam Rifles, the CRPF, the BSF. So what in those cases especially the courts have seen to be doing is that yes, it has to be prosecuted in a civil court, and army also has given permission or sanction. Like I said, the central government has given sanction for prosecution in civil courts, because they then do not form part of a bona fide military operation. right? So once the army has given its report, the central government has evaluated it, the government has itself taken cognizance that these incidents, of maybe the rape incident by the Assam Rifle troops was over and above the official duty for which they were actually given powers for. So therefore protection under AFSPA would not be granted to them, because the act very clearly provides that it has to be a bona fide military operation. So the moment you deviate from that, then you do not have protection. So
But
this,
many a times when this issue has been raised with regard to armed, forces personnel using their arbitrary powers, and if action is sought to be taken against them under the civil law, so most of the times the argument raised is that this kind of an action demoralizes the armed forces, posted in these troubled
definitely.
areas.
See, but I'm a little biased here, so I'm going to tell you that upfront. But see, from where I come from and the interactions that I have had, suppose it's a military operation going on, it's very easy for us to comment sitting, behind a comfortable television, seeing that, oh my God, this is happening. For troops who are on ground, the situation is very, very difficult. Suppose they've gathered all the intelligence information, they've been told that at this point, there's going to be an armed movement, there's going to be, something that's going to happen within this area. They're waiting for it, and then they see something like that happening, and then they react to it, right? So will that be a bona fide operation? Because if they don't stop it, then the consequences will also be graver. But there have also been instances where, yes, there have been cases of mistaken identity, but the moment the army or the armed forces have realized that, they've stopped. So it hasn't been that the retaliatory firing has been at a level which would cause harm or collateral damage. Yes, there have been cases of mistaken identity, but it's not the general concept, because once we scrutinize it at a later stage, there's always, oh, he could have done this could have been done, but it's not always the same when you're under the fire. So you have to understand that our armed forces, for one, are not trigger happy. Even with when we've been at war with countries, with Pakistan also, we've never been the first ones to attack. We've always waited for them to attack us first, and then retaliate in self-defense, and then go guns blazing. So similarly, for even the armed forces personnel within the country, if there have been instances, one or two sporadic incidents of mistaken identity, otherwise the checks and balances which they have within themselves, the sense of duty and responsibility that they have, I've personally seen that. So I think I can vouch for it that other than few instances where yes, there have been sexual exploitation, there have been rapes, but those people have also been punished under the law. Yes, exactly.
So any failure by any armed personnel under AFSPA, is that punishable?
See, yes.
Failure to act.
Failure to act. See, again, there are two parts to it, Bhadra. One is that if you've gotten information, so see, under AFSPA, you get immunity to do certain acts. And if once you do certain acts, then if you have to be prosecuted, then sanction is required, right? This also includes legal proceedings, suits, and other proceedings as such. So the issues have been whether legal proceedings will constitute an FIR, would also mean a charge sheet. The Supreme Court has in fact clarified that even an FIR means institution of a criminal legal proceedings. So yes, there is a lot of immunity that they have, but these are only, again I'll repeat, only for bona fide operations, right? So once you have all these checks and balances in place, then it is for the army authorities, the central authorities, to actually see that what was the mission for, and whether it was in furtherance of that operation. So once you deviate from that, normal law has to take its effect. You can't replace that then.
Right. But if you fail to act upon an information, my question
so then
was
again that would be under the Army Act. Suppose if then that would be disobeying your seniors' orders, or that there is intelligence input, but you fail to act. So if you don't act on it, still you would be court-martialed.
Okay, so you proceedings under court-martial.
Yes. So if you fail to act upon it, then yes, you're failing to do a duty which you were bestowed upon under the Army Act, the Air Force Act. So then that also comes into play. Then you have an internal mechanism for that. So think about it from this point of view, Bhadra, if you have an intelligence input and you act it might be a violation of human rights. You don't act, you might then be punished under the normal laws, so that it's a very thin line, and people who are on the ground will then have to think whether, this is the one that they have to cross, or what is the material before them that they have to evaluate. Probably you and I can't think about it, so that's upon them to then.
We spoke about initially how maybe this was introduced as a short-term measure,
Yeah.
and we've also had the Supreme Court comment on this law still being around. Do you think we've reached a point where this law maybe needs amendments or modifications or scaling back?
So, of course, scaling back is something that the government has been doing quite vociferously, be it the JNK or the northeastern states, the areas which they see that there have been improvement in. So, they actually remove them from the disturbed area notifications. According to me, we are not yet there where you can completely remove it, because then our armed forces in the border areas will technically be sitting ducks, right? So, they, once they don't have this immunity, they will of course be hesitant in going ahead and carrying out their operations, because they'll know that even if it's a bona fide operation, there would be a lot of people, who will be ready to, pinpoint towards them, or, rope them into false accusations. And if a person is embroiled in litigation, court cases, we see how difficult it is, So, with that stress in mind, with that issues in mind, nobody will be able to operate. So the next time they, even if suppose they're in a JNK state and they see that, there is a terrorist crossing the line, they say, let's just sit back, why should we get into it? So that's something that's again detrimental to our own security, So we need to give them a push, of course, with checks and balances, but scaling it back right now when we're actually still facing a lot of, internal issues would not be the best option.
With this, we've reached the end of this episode. Thank you so much for watching.